Good morning. Uh, Periodically, uh, the issue was that whether daughters are entitled for share in the ancestral property. Number two, whether they can claim partition of dwelling house. Prior to 2005, the daughters are only entitled for maintenance, and if partition is effected under section 6, they are entitled for some share. But that depends upon section 8 and rule 8, section 8 and section 6. Section 6 deals with the proportionary property. Section 8 deals with the property devolvement if male dies intestate. See, time and again the Supreme Court involved in this matter, multi-number of right from the Guru Bada case, which was starring case as on date. And that's what Dr. Ambedkar, while introducing Hindu Succession Act 1956 with the heavy heart, has said that he wanted to abolish section 6, but he could not do that because of dominant communities' pressure. After all, later that was done. This is the case where Karnataka High Court held two concepts. Number one, though the act has been brought into force from 9/9/2005, the daughters are entitled for share that equal to daughter, whether the death of the father was prior to 9/9/2005. There was no partition prior to 9/9/2005, and the partition is being effected after 9/9/2005. The daughter is entitled equal to son. The other one, they say the question of 23, which bore daughter to claim partition over the residential property, dwelling house. Since this section 23 was repealed with effect from 9/9/2005. This was the case law, very short, 2 paragraphs, 2 pages judgment. Kindly go through, that may help you in future course if anybody approaches, and you will be alerting, defending, or fighting for share to the daughters. Now let us go through the important provisions. 120A, 120B. See, criminal conspiracy. This criminal conspiracy abatement all are depends upon meeting of minds. Meeting of minds. It is not necessary that the accused must be present at scene of occurrence for prosecuting him under section 120A and 120B. It says, a citation was Bala Hajar alias Abdul Hamid versus State Representative Inspector of Police, 2018 for crime 183, Supreme Court. They say, offense of criminal conspiracy, a separated distinct offense, meeting of mind of two or more persons to do an illegal act or an act by illegal means, is sine qua non for invoking section 120B. Presence and participation of accused persons in such meeting alone is sufficient. Object for which conspiracy was aged has to be gathered from circumstantial evidence till the commission of the offence. Instantly, PW 3 and 4 in their statement establishing the conspiracy to kill Shiva. PW 3 and 4 being natural witness and their statement being consistent and reliable witness. Held courts below rightly relied on testimony of PW 1 and 4 to sustain applicant conviction under section 120B IPC. In the recent case, Dr. Kamaraj murder case, that 120B was played a vital role, and fortunately the prosecution was able to establish the evidence against the conspirator on the basis of CCTV cover footage and approval evidence. They say reading of section 120A and section 120B makes it clear that an offence, criminal conspiracy, is a separate and distinct offence. In order to constitute a criminal conspiracy and to attract its rigor, two factors must be present in the case on facts. First, involvement of more than one person, and second, an agreement between among such persons to do or causing to be done an illegal act or an act which is not legal but is done or causing to be done by illegal means. Therefore, in order to constitute a conspiracy, meeting of mind of two or more persons to do illegal act or by an act by illegal means is must. In other words, it is sine qua non for invoking the plea of conspiracy against that. However, it is not necessary that all the conspirators must know each and every detail of the conspiracy which is being acted, and now it is necessary to prove their active part role in such meeting. In other words, their presence and participation in such meeting alone is sufficient. It is well known that a conspiracy is always acted in secrecy and is never an open affair to anyone, much less to public at large. For this reason, it is existence coupled with the object for which it was actually has to be gathered on the basis of circumstantial evidence. Such a conduct of the conspirator, the chain of circumstances leading to holding of such meeting till commission of offence by applying principle applicable for appreciating circumstantial evidence for holding the accused guilty of commission of offence. They have followed Baldev Singh. Baldev Singh case is being referred in almost all cases of conspiracy. Having scanned the testimony of PW3 and PW4, we find no good ground to discard their testimony. In our opinion, their testimony is found natural, consistent, and does not suffer from contradiction. So, this is what 120. Therefore, they say in one another case, Bilal Hajar vs. Abdul Hamid case, you see, this is also most important to understand 120. Pasting of posters on 19/8/1990 in public places all over the city announcing to kill Shiva and 6 others. Shiva uttering filthy language against a member of the community to which the accused belonged to in a public meeting on 30/8/1991. Evidence of PW3, PW4 proving the factum of meeting held in appellant's house on 1/1/1991 with other accused, wherein decision was taken to eliminate Shiva within 10 days. Killing of Shiva after 5 days. Absence of appellant from the scene at the time of actual commission of the offence held immaterial. So this is most important to understand 120B, these two cases. This case, the second I read, pasting posters. Bilal Hajar alias Abdul Hamid, State 2018 4 crimes 183. Now you this like Baldev Singh case, for conspiracy they may ask questions on objective type. Baldev Singh refers to what? Kesavananda Bharati case refers to what? Basic principles of Constitution. Then what about Minerva Mills case? Then locomotive right, Manaka Gandhi case. Like that, this you should keep in your mind. I will cite again and again for your better understanding. Thank you very much.